Thank you for the opportunity. Mr. Speaker, I write fortified by Article 4A of the Constitution, 4A of the 1992 Constitution, which requires of me, Mr. Speaker, at all times, to defend this Constitution. Mr. Speaker, accordingly, Mr. Speaker, I may want to open the Constitution for them. Mr. Speaker, I may want to open the Constitution for them. Mr. Speaker, I may want to open the Constitution for them. Mr. Speaker, Mr. Speaker, Mr. Speaker,
Honorable members, please, let's listen to him.
Mr. Speaker, with your leave, I read Article 348. Mr. Speaker, with your leave, I will read the provisions allowed. Article 348. It provides, all citizens of Ghana shall have the right and duty at all times to defend this Constitution, and in particular to resist any person or group of persons seeking to commit any acts referred to in clause 3 of this article. Mr. Speaker, on the strength of this provision, I raise my preliminary legal objection to the motion moved by the minority leader on the following grounds. 1, that by considering this motion, the Parliament of Ghana will be encroaching on the province of the judiciary, acting ultra vires, where it purports to sit and determine the veracity of the grievous allegations found in this motion. 2, that there will be a parliamentary attack on the constitutional requirement of a fair hearing if this motion, this House proceeds to hear, debate, and determine this motion without first putting in place a detailed procedure for hearing the minister in his defense. Mr. Speaker, I'm led by the Honorable Majority Leader in raising this preliminary objection. Mr. Speaker, I shall proceed to argue 2 of the grounds, and he would come in to do further elucidation. Mr. Speaker, first. Mr. Speaker, first.
Honorable Deputy Majority Leader, did I hear you say that you will raise the preliminary objection, put across your views, and another person will come to support the preliminary objection? Did I hear you say that?
Mr. Speaker, you understand it better when I say I'm led. Mr. Speaker, what I mean to say is that we have a joint enterprise, and I shall proceed with the argument, and then there will be elucidation. In other words, Mr. Speaker, I will not exhaust all the grounds, but I will cede to him, and all these will come as a result of your leave. But Mr. Speaker, as it pleases you, for now, I will proceed with my right as granted to proceed.
I think it's proper for you to raise it end it as preliminary objection, then we can proceed from there. We don't need to bring any other person to come and support. It means that you yourself are admitting that what you're going to put across will not be sufficient. Don't do so. Go ahead.
No, go. I'll go. Mr. Speaker, as it pleases you. No. Mr. Speaker, I proceed with ground one. The ultra vires of Parliament in seeking to pass a vote of censure on the Minister of Finance as provided for in Article 82 of the Constitution. Mr. Speaker, some of the statements captured in the motion paper include despicable conflict of interest in ensuring that he benefits from Ghana's economic woes. Mr. Speaker, these are very severe allegations that require more evidence than the pedestrian allegation. Mr. Speaker, it cannot be that a Minister of State will be brought here, Mr. Speaker, for censure when the grounds of such application have not been properly laid out. Mr. Speaker, if we allow this to happen, and Mr. Speaker, I do not want to be tempted into believing that my attempt in inviting this House to adopt laid-down procedures as practiced in our court, of which Honourable Minority Leader claims that these are inferior. He says they are inferior. I do not want to be tempted to believe that he doesn't believe in the due process that is practiced in our court. That if Parliament adopt due process, it will ensure certainty, it will lead to legitimate expectation, and it will lead to a situation of fair trial. I do not want to believe that the Honourable Minority Leader today is saying that introducing rules of courts into this House are not acceptable. I do not want to believe that. Mr. Speaker, it is not to be confused. The provision in the 1992 Constitution should not be confused with Article 125 of the Constitution. Mr. Speaker, if you look at the allegations as tabled by them, they are more or less subjecting the minister to a trial. These are matters that, Mr. Speaker, upon proper scrutiny, they are criminal in nature. The minister is a citizen of the Republic, holding a public office. If the minority is so convinced that he has committed an offense or his conduct is criminal, Mr. Speaker, there is a process to follow. You cannot, and I repeat, you cannot rely on Article 82 to say that indeed you are bringing a censure application to remove him from office. I dare say that, Mr. Speaker, on that score, they will be arrogating to themselves, or they will be inviting this House to arrogate to itself judicial powers, which we do not have. And Mr. Speaker, even if we would want to constitute ourselves into a quasi-judicial body, an administrative body for the purpose of conducting inquiry, we must be guided by Article 23 of the Constitution. We must be guided by Article 23 of the Constitution. Therefore, Mr. Speaker, it is my contention that the conduct of the minority, by way of outlining all those allegations without grounding the same on facts, will be repugnant to good conscience and fairness should we proceed to hear them. Mr. Speaker, we are not in any way attempting to say that we want to usurp the powers of the judiciary. If you look at the content of the motion paper, clearly, everything they are saying, their reliefs lie elsewhere, not in this chamber, in the shape and form. Mr. Speaker, if for the avoidance of doubt, they really want to exercise their power of oversight, they have an opportunity to file a question, which question would have given the minister an opportunity to respond for the fact to be known. As the Speaker said, censure is a very serious matter upon which we cannot allow trivialities to overtake it. Mr. Speaker, I shall proceed with ground 2, which is parliamentary attack on fair hearing. Mr. Speaker, for this purpose, I shall refer us to Order 106, 107, and 108. Mr. Speaker, it is my case, Mr. Speaker, that 106 provides a detailed procedure for the removal of President, Vice President, Deputy Speaker, and also makes mention of vote of censure on a Minister of State. If you come to 106.2, Mr. Speaker, for emphasis, 106.2b, it says that the notice shall be accompanied by a detailed statement of fact to prove that the conduct or the physical or mental capacity of the President or Vice President should be investigated. Mr. Speaker, by parity of reasoning, there's something called parity of reasoning. Parity of reasoning. Mr. Speaker, if you read the A, it also talks about notice. If you move, Mr. Speaker, to 107, I would want to read A, B, and C. And this is what it says, Mr. Speaker. A talks about 7 days notice. B talks about the motion to be debated in 14 days. But for emphasis, C, this is what it says. Prior proceedings shall be taken in a committee appointed in that behalf. The Speaker or the Deputy Speaker shall be entitled to be heard in his defense, either by himself or by his representative. Mr. Speaker, 108 specifically talks about censure. I contend that the lacuna found in 108 can only be cured if by parity of reasoning we apply 106 and 107 provisions mutatis mutandis. Mr. Speaker, for emphasis, it is my submission that the supposed lacuna in 108 can only be cured if we read 106 and 107 together and apply the provisions therein, mutatis mutandis. Mr. Speaker, that is the only way we will be ensuring fair hearing. After all, Mr. Speaker, it is clear that since the Constitution made this provision, we as a House, I don't want to say we have failed, but we as a House have not enacted in extenso to guide the rule of procedure to be followed. Mr. Speaker, what is rule of law? What is rule of law? Rule of law is about due process. It's about rule of procedure. It's about rule of fair hearing. It's about notice to the party whom an allegation is made against. Mr. Speaker, we cannot say that merely the Constitution providing for us to move a motion on censure, we will therefore arrogate that power, go ahead to file a motion on ex-cathedral grounds, not grounded in reason, fact, and law, and then say that a public officer whose office, Mr. Speaker, this House approved, should be dismissed, or that his instrument of appointment should be revoked. Mr. Speaker, I refer us to the United States. We don't have a precedent in this House. The attempt that was made in 1999 was not carried through. Therefore, Mr. Speaker, let's go to the United States of America. In the United States of America, where a bill of impeachment is brought to the House, by members of parliament who are called managers. Mr. Speaker, the first step is for them to establish a prima facie. By establishing a prima facie, Mr. Speaker, they go through the motion at the lower house. And going through the motion in the lower house, by 1/3 of votes, this is ferried to the second chamber, the Senate, where a full trial commences with the Chief Justice of the United States presiding. In this case, the applicants, who are members of parliament, are allowed as quote-unquote the prosecutors. They make their case, the party is heard. Mr. Speaker, in our case, unlike the United States, they had the broader provision in the Constitution. They went a step further to enact a rule of procedure to guide the process. Mr. Speaker, I dare ask my colleagues, they should tell us whether as a house we have a rule of procedure to regulate censure. Maybe today it is Ofori-Atta. So crucify him. Crucify him. But Mr. Speaker, when in 1999 the issue arose, I have the comment, the veritable words used by Honorable Cletus Avoka. I've read it, where he was talking about the right of fair hearing. I have it here. I've read it, where he argued forcefully with some nostalgic effect that the person must be heard, that the proper thing must be done. Mr. Speaker, what is good for Kwame Pepra is good for Ofori-Atta. What is good for the goose is good for the gander. Mr. Speaker, we cannot construe this application to be properly before us. If we go ahead, Mr. Speaker, to consider this application, we'll be doing a lot of injustice to our colleague. Mr. Speaker, let's read Article 23 of the Constitution. Okay. Mr. Speaker, Article 19. Mr. Speaker, first Article 19. Mr. Speaker, 2D provides, a person charged with a criminal offense shall be given a fair trial within a reasonable time by a court. Now, Mr. Speaker, 2D, be informed immediately in a language he understands and in detail and of the nature of the offense charged. Mr. Speaker, again by parity of reasoning. Again by parity of reasoning. The minority should not create any impression that anybody here or the majority is against their motion. But Mr. Speaker, due process must be followed. Mr. Speaker, Honorable Atuforsen is before a court of law. Is it the case that he has just been sent to prison? He cannot be sent to prison. He must be heard on allegations. He must be heard and he must defend himself. All of us here as politicians, should anybody raise an allegation to come up with anything of corruption, of whatever, you expect as your bona fide to be given fair hearing. And fair hearing includes all documents to be relied on by your adversary to be made available to you. Mr. Speaker, again, Mr. Speaker, let us look at 2E, and I will use that as the override. We cannot place something on nothing. It says, the person be given adequate time and facilities for the preparation of his defense. Mr. Speaker, as it stands now, if this motion is allowed to proceed where there will be debate, it would amount to injustice, unfairness, in the sense that the minister wouldn't have been given adequate time to prepare for his defense. Mr. Speaker, the grounds upon which they raised, the grounds upon which the motion was moved, these grounds were not made available to the minister. They are so-called evidence. has not been made available to the minister. Mr. Speaker, disclosure is an integral part of any civil or criminal jurisprudence. And even in recent case, Mr. Speaker, the Supreme Court of our land has ruled that prior to criminal trial, every document that the prosecution, Mr. Speaker, will rely on must be made available to the accused. Mr. Speaker, how do we proceed to debate this motion when even as members of parliament who are expected to vote upon this motion do not have copies of the evidence upon which these members rely? We are here, we are expected to vote. Mr. Speaker, this is not political talk as usual. This is not the usual political rhetoric. This is about the reputation of a Ghanaian citizen serving his country. This is about a fellow politician who is serving his country as a finance minister, who members of this house are alleging that he's committed certain infractions, committed certain offenses, and they have documents with them, and they expect that by merely raising the issue, we should trust their judgment enough, rely on them, vote without having evidence, without having ability to peruse that which they rely on. Mr. Speaker, no justice system. Mr. Speaker, no justice system. No justice system anywhere in a serious democracy will allow this. Mr. Speaker, I move on to Article 23 of the Constitution. Mr. Speaker, Article 23 of the Constitution, I read, administrative bodies and administrative officials shall act fairly and reasonably and comply with requirements imposed on them by law, and persons aggrieved by the exercise of such acts and decisions shall have a right to seek redress before a court or other tribunal. Mr. Speaker, emphasis fairness. And if as parliament we cannot grant such a sine qua non right provided for in Article 23 and ensure its implementation, its enforcement, especially when a finance minister is being put on fire, Mr. Speaker, then, Mr. Speaker, with the greatest respect, we will not be doing justice to the Constitution. Mr. Speaker, above all, Article 296 is very profound. Article 296 is very profound. Mr. Speaker, I'm surprised some first-timers want to intimidate me. Mr. Speaker, if you give them even 1 minute, they can argue. Yet they can talk when they are not. They can make argument not for the record. I would want to sit down for you to come back and argue. Can you? Mr. Speaker, Article 296 of the Constitution. Mr. Speaker, 296 of the Constitution requires of us, Mr. Speaker, by parity of reason, requires of us not to be capricious, not to be biased, not to be unfair. 296 expect of us to be candid in our dealings with our fellow citizens. Mr. Speaker, having stood on my feet for 15 minutes, I shall at this point, Mr. Speaker, cede the rest of my argument to Honorable Chair Mensah Bonsu.